Good afternoon, everyone. This is the Orca final plea calendar. I'm Judge Eric Moore, and we'll be presiding in court this afternoon. Let's see who we have present. Position number one, Med Abdusimid.
Good morning, Judge. How are you?
Yes, good afternoon. Good to see you.
Good to see you. This should be a negotiated. I just need a few minutes to speak to Ms. Reiser.
Okay, Ms. Rogers not going to be here this afternoon. They're in training, I believe. Let's see, Ms. Riley or Ms. McCutcheon, whose case is this?
Good afternoon, Your Honor. ASG Briley. I have positions 1 through 10.
Okay, thank you. Counsel would like to speak with you prior to a plea this afternoon, so we'll give him that opportunity.
Okay.
All right.
And Judge, how would I go about speaking?
Oh, we can. Do you have your laptop? You can either go on the laptop, or you can call. Or she can call you, or you can call her.
Okay.
All right. So let me get to the end of the calendar, and then I'll let you all communicate. Position and is your client in court with us?
Yes, Judge.
Okay, very good. Good afternoon, sir. Position number 2, Jaquavius Alexander.
Good morning, Judge. That's my client. Is Mr. Alexander present? Is Mr. Alexander present on Zoom?
I'll hold for your announcement, Mr.
Thanks, Judge.
We've already dispensed with position 3 this morning. That's going to be an October jury trial. Position 4, Harry Bloomfield. Okay, good afternoon, Mr. Bloomfield. Ms. Rockwell with us? Okay, we'll hold for your attorney's announcement, sir.
Mr. Stinson, can you mute your audio, please?
Position number 5, Latoya Dixon. Latoya Dixon. Bench warrant will be granted if Ms. Dixon does not appear by the end of the calendar. Position 6, Ian Dowlathkah, Dowlathkah.
He is present. I actually represent him on another case that I'm not sure why it didn't make it on the calendar. That case, it was sent to diversion. He completed the class, but I just want to look the court now. I'll follow up with the prosecutor. But as far as this case, Judge, he's represented by Thomas Nagel, and he's present.
Okay. Let's see if we can raise Mr. Nagel, see if he's going to be present this afternoon.
And I have the case number of my case number if the court wishes to hear it, but it's not on the calendar. But it's a diversion case, and I'm assuming it's going to be null placed anyway. So
Okay, so has your client already done diversion?
he has completed the class that he was supposed to take. I think he completed everything, and I believe I forwarded it to the prosecutor. But it's really, I mean, we can wrap it up.
Okay, I want to go ahead and null process it if we can.
I'll double
Just
check
so
we don't make sure.
Do you have that, Ms. Riley? Do you have the diversion completion?
I do not. I can look him up, but if you have the case number for the other case, that would be. Great.
I'll email you, Ms. Riley. I'll email you what I have.
Okay.
And I think that's the only thing he was supposed to take, that one class that he completed, but I'll email you everything and we can figure it out.
Okay.
Thank you.
Thank you, Judge. Sorry about that.
Oh, it's no problem. Position 7, Colin Fikwa.
Good afternoon, Judge. Mike Stinson for Mr. Fikwa. He should be on the Zoom. I would like a brief pretrial with the solicitor's office, Judge. But
Okay.
short of that, we're gonna announce we're ready for trial.
Okay, Mr. Stinson, let me let you speak with Ms. Riley in a breakout room today for you all to discuss to make sure you have everything you need. And then you can report back, okay?
Thank you, Judge.
You're welcome. Position number 8, Brianna Glover. Yes, Ms. Glover. Ms. Rockwell is your attorney also. I'll hold for her announcement. Position number 9, Rodarius Green.
Good afternoon, Your Honor. Mr. Goldberg, I'm covering Mr. Green. He should be present on the Zoom. He was given permission to do so on the last court date. I've spoken with Ms. Reiser. I didn't know she wasn't going to be here today. We're trying to work things out. We're in talks, and I think the consensus was to move this to the next trial calendar. I don't know when that is going to be.
Okay, that will be further notice for the October jury trial calendar. We don't have that set yet. You'll get notification.
And just for your honor, I do have I don't know if the court doesn't know when that is, but I do have a federal trial going out in Northern District of California starting on October 9th, which probably lasts about 3 weeks. So just
November jury trial calendar work better for you?
November?
Yes.
That'd be great. And I anticipate this will be resolved before then.
Okay, we'll place you on the November jury trial calendar. If you all do resolve it before then and want me to place it on another calendar so we can resolve it before November rolls around, I'm happy to do that. Just contact the clerks and we'll put you on the calendar if you're all able to work it out, okay?
Okay, thank you, Your Honor.
All right.
That's all. Have I be excused?
Yes, have a good day. Thank you. And Mr. Green's on Zoom, is that right?
Yes, sir.
Good afternoon. I'm doing well, so good afternoon. You're free to go. I'll see you back in November.
Okay, thank you.
You're welcome, sir. Position number 10, Pierre Guy.
Good afternoon, Judge. That's going to be my case. Mr. Guy is present here on Zoom, Judge. We've received the videos in this case, and Judge, we're prepared to request a jury trial and be set on a jury trial calendar, Judge.
Okay, we'll further notice you to the October jury trial calendar.
And Judge, that is in person, correct?
Yes, all hearings and bench trials and jury trials will be in person.
Because Mr. Pierre Guy is a full-time truck driver, so I just wanted to clarify that that's going to be in person.
Okay, yes, Mr. Guy, you would have to appear in person and not on the road for me, okay? All right, you're free to go today, Mr. Guy. You have a good rest of your day. Be safe out there.
Thank you, Judge.
You're welcome. Position 11, Portia Harshaw.
That's going to also be my position, Judge. I believe Ms. Harshaw is present there in court. Judge, I'm going to announce pre-trial. I don't have the videos, I don't have the warrant, and I don't have the police report. And I believe the last communications I had with ASG Reiser is that there may not be those things. So Judge, I would just announce pre-trial to see where we're at with the discovery.
Okay, I'll have you talk to Ms. McCutcheon today. Is Ms. Harshaw on the line or in court?
Well, I spoke to Ms. Harshaw. She informed me she was showing up in person, Judge.
Okay, well, I don't see her here. I will,
If not, Judge, just give me an opportunity to the end of the call on the calendar to get Ms. Harshaw.
okay, that's fine, Ms. Helen. Position 12, Tiara Jones.
That is also my case, Judge. We have not received videos. That's the only thing we're waiting on. So I will announce pretrial to see when those videos could be sent. But I'd ask for a reset, even if I were given the videos today, just to review that with Ms. Jones.
And Judge, I'll just say Ms. Reiser's notes that I have are very up to date. She sent them a day ago. So what she has indicated is that we have requested the body worn camera, but we have not yet received it.
Understood. So Judge, I would just ask for a one-time reset, just get those videos.
Ms. McCutcheon, I'm only hesitating because I keep resetting these cases for videos to come in, and they don't seem to come in, and I keep resetting them. And I know that's not your the solicitor's fault, but we can only push these cases down the road so many times before we start piling up again. So I'd like for you to discuss that with the powers that be, if you could, to let them know that that's a problem that we're having. I don't know if the other courts are having that same problem. I'm sure there must be, if this court is, just to see what we can do about that. And I'm resetting many more of these cases than I want to because of that reason.
And Judge, and I'll just, yes, I understand, Your Honor, respectfully. I noticed that from this morning's calendar, the number of resets. Ms. Helen, I do have Ms. Reiser's offer that she indicated she emailed to you on July 27th.
We
It's a
do have the offer.
probation offer. Okay. Mhm.
Okay, I'll allow you all to talk regarding that. I just wanted to make a note of that.
Understood.
Thank you. Position 13, Preston Lee.
Good afternoon, Judge Ibrahim Awad on behalf of Mr. Lee. We're edging toward a resolution with Ms. Reiser. We think we'll have one prepared for you.
Okay, for today?
I believe so.
Okay, very good. So you, Ms. Reiser, unfortunately, many of the solicitors are in training today. So Ms. Reiser won't be here in person. We do have Ms. McCutcheon on the line that I will allow you to speak with to see if you all can come to a resolution, okay?
Great.
And Your Honor, I'll just make the court aware that Ms. Reiser is the supervising attorney for these calendars, and she has made, her notes indicate the offers that she's made. And so I would be unable to deviate from those offers. Those are the offers that she's already determined to be appropriate for the case.
So
I mean, I'm willing to talk to anyone that wants to talk to me, but I won't be able to deviate from Ms. Reiser's offer.
we received multiple offers, so that's
Okay, well, so you want to clarify it?
yes.
Okay, so we'll clarify what the last offer is. I'll give you that opportunity.
Thank you, Judge.
Okay, you're welcome. Position 14, Kayla Murray. Yes, Ms. Murray. Mr. Don, is that your office?
Judge, it is Ms. Helens and I.
You skip. Preston.
No, they talked.
Apologize. Didn't realize that I was muted.
The numbering's different. I don't know why.
And Judge, that's for Miss Murray, correct?
Yes, 14.
I've also spoken to ASG Stevens. That is going to be a diversion case. We've sent some mitigating information to ASG Stevens. And currently that's in the process of diversion, but he's in training. So I would just ask for a one-time reset. So.
Well, Judge, the notes indicate that the diversion offer was emailed in June.
I talked to ASG Stevens. He thought Helen was my first name. So he sent it to the wrong address. He actually forwarded to my correct Fulton County email as of yesterday or the day before. I apologize. Let me pull it up.
That's fine, Ms. Helen.
So is it just a matter of needing the diversion paperwork, Ms. Helen?
That and there were conditions that he wanted completed. So I never received the original email. And that's what we talked about, ASG Stevens and I. And so he then sent it, and then now we just have to do what's being asked. I think there may be a class, fill out the paperwork, and then that should be that diversion program.
So, Ms. Helen, if I reset this for October 4th, the status conference calendar at 9 a.m., can you get everything that you need together and maybe have your client do the diversion so we can get this null pros?
Understood, Judge.
Okay.
Yes.
So we scheduled for October 4th. 9 a.m. status. Is Ms. Murray on the line with, oh, yes, Ms. Murray.
She's in court.
Yes, ma'am. So I'm going to reset your case so that you can get through the diversion class. Ms. Helen will be in touch with you to get you that information, okay? Do you have any questions for her?
No, do I stay?
You don't want to stay with me this afternoon? You're free to go, ma'am. Have a good afternoon.
Thank you.
You're welcome.
Thank you, Judge.
Position 15, Kirsten Alterman.
Good afternoon, Judge. That is my client. Which prosecutor is going to be handling it this afternoon?
That'll be me, Mr. Haddad.
All right, Ms. McCutcheon, Judge, I do have a plea worked out. I will send the old-fashioned paperwork to Ms. McCutcheon to review. There's one minor issue, but I'll discuss it with Ms. McCutcheon. I'll send it by email, Judge, but I do expect a resolution this afternoon, Judge.
Okay, very good. Thank you.
Okay.
Position 16, Coleman Reed.
Judge, Mr. Reed is present, and Judge, I can see where this is going. So we're still missing a video, but what I would ask the court, maybe go ahead and set it on a jury trial calendar, Judge. With the understanding that the offer is still potentially open, well, subject to the video. I mean, I don't know, but I don't like resetting cases.
No,
And it's a straightforward case, frankly, Judge. It may end up maybe being a bench trial, but for the time being, if, you know, I'll go ahead and announce, set it for a jury trial, Judge, for October, whenever the court wishes.
do you want me to put it? Oh, go ahead. Ms.
I apologize respectfully, Your Honor. I was going to inquire, and I hate to interrupt you, Judge. I apologize.
No, go ahead,
Um,
Mr. McCutcheon. You're
okay.
fine.
My notes indicate, Mr. Haddad, that Ms. Reiser shared the body worn camera on July 27th. So did you
Right.
not get the link?
No, it's not the body cam. It's actually the video for the skating rink where the alleged theft had happened. So it's not your typical video. And that's what the issue is.
Okay, so apparently we don't have that. So I will make certain that I speak with Ms. Reiser about that, but there's no indication that we have it. So you're saying that you've requested it, and that's the whole.
Right. So I think, if I'm not mistaken, Ms. Githia, the last calendar had mentioned it, and I believe she was put in the request because it's a private business video. There's indication of that in the police report. That's how I knew. Now, I assume that it was requested. The last conversation I had with Ms. Reiser is that there's still no video. She did make a different recommendation, but my client is not interested still. So instead of just bouncing it around, Judge, I would still propose maybe a jury trial. And if the video pops up. If not,
Okay, all righty.
still with it at that point.
You want a jury trial or a bench trial, Mr. Haddad?
Let me check with Mr. Reed, with the court's permission at the end of the calendar. And if he can be, well, I'll check before the court excuses him.
Okay.
I don't know what he wishes.
Okay.
I'm unlike Mr. Corn, Judge.
Well, and let me just explain why, that, and I know you know that situation. There's certain cases that the solicitor's office is always objecting to. I want to give them the opportunity. I don't think this would be one of those cases.
No, Judge.
It's nature.
It would not. I mean, I think I can speak for Ms. Reiser. This would be her case. This would not be, the state would not be objecting to a bench trial. And of course, the state understands. I'm looking at the age of the case. It's a 2020 case. We will strive, Your Honor, to get the video. Apparently, it's not in the hands of law enforcement. We will strive to get it from the skating rink, a private entity, understanding that if we cannot get it, obtain it and provide it within 10 days, then we would be unable to use it.
Okay, thank you, Ms. McCutcheon. Position 17, Khadijah Shabazz.
Good afternoon, Judge. Mr. Shabazz is present. Judge, this case, I intend, we pretty much gonna work this case out as a negotiated plea. However, Mr. Shabazz has a second case that is open. It's 22 CP 210311. And it is basically our interest to try to resolve both cases. And I understand that the new case, I don't even know if it's been accused yet, but it's in the solicitor's office, because as far as I understand, it's a misdemeanor. And so I would like to give the state time to accuse it and get it sent here so we can resolve both cases. Because what's going to happen? It will plead her, and then she's going to be back on the new case later.
And Your Honor, the state is all for resolving.
I'm sorry, Ms. McCutcheon. Whoever Carla is, can we get her muted, please? I cannot hear.
And of course, Your Honor, the state is all for moving the court's business as efficiently and expeditiously and resolving multiple cases. However, if that case still has a CP number, and I'm trying to look it up now, it's not in our office yet. It's not in our office until the CP number, which is the Superior Court, formerly complaint room number, until that's removed, Mr. Gaither. But I'll look it up and see but until that's removed, we don't have the case and we cannot accuse it. But I'm looking the case up now.
Okay.
Do we know the charge?
I was under the impression it was a family violence battery because it involves her husband.
Okay. All right. You want to go back on a final plea calendar?
Yes, because like I said, the case that's in front of you today, we pretty much have worked out, but I would just rather work out both, because it's in our best interest just to work out both and to plead one and then bring the next one back and plead the other one.
Okay, it'll go on the October 4th, final plea calendar at 1:30. Does that work
Okay.
for you, Mr. Gaither?
It will. And then what will happen, so what I propose is that even come October the 4th, if that CP case is still open, that I'll just recommend we just go and I will recommend to Ms. Shabazz, we just go and deal with the case in front of us instead of just keep kicking the can down the road.
Okay. Do you need to speak with Ms. Shabazz before I dismiss her?
No, I spoke to her before the call of the calendar.
Okay, you can have a good afternoon, Ms. Shabazz. Position 18, Christine Shope.
Good afternoon, Judge Shane Kane from this show. She's here. I guess the solicitor isn't here, or they're on the Zoom.
They're on Zoom this afternoon.
Okay, we don't have a resolution, so we just have to go into a trial calendar.
Okay, we will further notice you to the October trial calendar.
October. Understood.
Do you have everything that you need from the state?
Well, I've got the video. I mean, if that's their case, that's their case. I will, I guess, let Ms. Reiser know. It is not the video of the arresting officer. I don't know if they can get it or not, but that's not your concern. Will there be a calendar call or will we be special set? How does it go from here?
There'll be a calendar call.
Calendar call. Okay.
And just be ready to go, because if you don't have a plea on that date, then a lot of cases fall off. So if I were you, and you're on that calendar, I'd be set to go then.
Okay, well, the case is only 4 years old.
I
so
know,
think
so
we
we're
can-
trying to get it moved.
I think we can. Thank you, Judge. Are we free to go?
Yes. have a
And
good-
and counsel, I'll make Ms. Reiser aware, you're saying that the video that she shared with you on July 27th is not the video of the arresting officer. I'll make her aware of that.
Correct. It is the backup officer.
All right. Thank you,
Yep.
sir.
Okay.
Thank you. Have a good afternoon. Position 19, Sean Turpin.
Really very for Mr. Turpin, he's present. Your Honor, we are in receipt of discovery and
So can I interrupt the judge and ask him about it or no?
Ms. Carla, not right now. You can
Oh.
interrupt me in a minute. Put your mute on for me. Yes, ma'am.
So, yes, Your Honor. So on Mr. Turpin's case, we are in receipt of discovery and a plea offer, but we have reached an impasse, so we are ready for jury trial.
Okay, I'll place you on that October trial calendar also. You'll get notification. It'll just be a further notice.
And you said, Your Honor, at the beginning of that calendar, there would be a call of the calendar, but then trials would start that day.
Right, what has happened in the past is that a lot of those cases will fall off. So once we get to the end of the calendar, I'll place you in order as to what will be tried. But just take it that if you are ready to go to trial, that it will probably go that during that week. Okay.
Perfect. Thank
All
you, Your
right.
Honor.
Fantastic. Have a good afternoon.
Thank you, you too.
Ms. Rockwell, are you with me?
Yes, Judge.
How are you this afternoon?
Not as good as you, Judge. I
Let's
do have
see.
two slots on the menu.
Yes, you
And Judge,
do.
those negotiated pleas. Hearing that y'all now have some kind of DocuSign available and all that. That's what I heard anyway. If not, Judge, if you give me 5 minutes just to complete the paperwork, I've got negotiated pleas from Madam Prosecutor Reiser, and I'm sure that I'm listening to Deputy McCutcheon, and I'm sure she's gonna she'll honor those offers.
Hello, gracious opposing counsel, Ms. Rockwell. I've retired from being a deputy, but thank you still. I'm no
Okay.
longer a deputy, but if Ms. Reiser has extended an offer to you, then of course I'm going to honor that offer. What positions is your case?
So I have Kerry Blumenfeld. I think he's number 4. And let me apologize for being late. I was, I was in another Zoom. So thank you so much. I also have Brianna Glover, whose case has a little age on it. So she might even be even closer to the top than Mr. Blumenfeld. Brianna Glover.
She's position number 8.
Those are actually all with ASG Riley.
Okay. Oh, okay. Sorry. Okay.
No
good.
problem.
All right.
But yes, I will honor Ms. Reiser's recommendation.
Okay.
Okay, so if we can.
Judge, I'll just stand down because I know a lot of people are before me in line. I just need to get very quickly. I do have blank plea sheets. I got kind of thrown off when I heard that y'all do DocuSign now. So if I can just go through the rights with the client, I'll do it the old fashioned way or the new fashioned way, however you want to do it.
Ms. Riley, what's easiest for you?
Your Honor, I'm having some issues with my version of DocuSign. So if Ms. Reiser had not sent the documents to Ms. Rockwell via DocuSign, please fill out the blank forms that you have. And
Okay, I'll stand down then, and
Okay.
I'll wave to y'all when I'm back.
Okay.
I'm just
Thank
gonna
you.
ask both of my clients to go outside and I'll talk to them on the telephone, if that's okay.
That's fine. So, Carrie Bloomfield and Brianna Glover, if you all will step outside so you can speak with Ms. Rockwell. And once you've completed the paperwork, we'll take those, please.
Thank you, Judge. Good to see you.
Okay.
Thank you so much
You're
for helping us, Judge.
welcome.
You're getting
It's
a
not
lot
problem.
done.
Trying to. Let's see. We have someone from this morning's calendar that I'm told is here this afternoon. It's position 14 on the Orca status calendar. Miss Dominique Hurd. Miss Hurd with us? Yes, Miss Hurd. Let's see. Do you have private counsel representing you on this matter? Would you like to make application for a public defender today? And what happened?
You talk to me? Okay, well, you know what? Now your face is familiar, but I didn't recognize her. So Judge, I will represent Ms. Hurd. I'll represent Ms. Hurd, and so let me just the same announcement. Just put her on that October the 4th final plea calendar. I'm certain we'll be able to work it out prior to then.
Okay, all right. So let me start with the courtroom. Is there anyone in court that came in late or didn't hear their name? Yes, sir. What's your name? Oh, yes, you're Mr. Gaither's client. Is that this is your client?
Oh, I'm sorry. I thought you were still, yes, this is Mr. Alexander, Judge. He's position 2.
Okay.
And so I would like to make a offer. What I want to do is just go ahead on and place him. He's a special case, and let me explain why. Put him on the next final plea calendar because identity is an issue in this case. Ms. Reiser and I have already talked about it. She's fully aware. We're looking into it. This case involves a 13-year-old who was struck with an object and was bleeding. And what's going to come down, what's going to happen is, I'm making a profit. My client saying, look, when he saw the video, he said, look, I don't know that little kid. I don't know any of the people in the video. It's not me. The names are different. It's the same first name, different last names. So the identity is going to be really pretty much dispositive. If it comes back that it's not him, the case against him goes away. If it comes back that he's probably is the person in the video, then either it's going to be a trial or it's going to be a plea, negotiated plea.
So
To be specific, so his first name is Jarquavis, okay? In the video, the father of the person who struck the 13-year-old, the father said, yeah, my son's name is Jarquavis Jones. In the police report, it keeps saying Jarquavis Jones. I'm still trying to figure out how did they even arrest my guy and what identification did they use to tie him to this incident, because my client, his position from day one has been, that's not me and I don't know anybody in the video. So I would just give him his Reiser because I know she's in training, just give an opportunity to look into it because she's fully aware of the situation.
So you want her to look at the video and
I think
see that it's not your client who allegedly committed the bad.
Right. To take a second look at it. I think she was going to pull some photographs and present it to the complaining witnesses to see, is this the guy that you all said struck the little boy or something like that.
Okay. You have any notes, Ms. Riley, that that Ms. Reiser has begun to do any of that?
Let me double check our internal system. I just have the recommendation on here. Give me just a moment. I was looking at that.
Or if not a final plea calendar, we can put it on a motions calendar. I can file a motion to argue for identity. I can be creative in that.
And
Well, I mean, if she doesn't agree with you, then we're just right back in the same situation we're in, right? You saying that it's not him, she's saying that it is him, and it's up to the state to prove it. Right?
Well, yeah, but I guess I just wanted to, I was trying to avoid the going back and forth. That's why I came to Ms. Ross and hey, look, take a hard second look at this to see, hey, look, because if it comes back not him, then the case goes away. If it comes back him, then the case still may go away because I'm gonna, based on my discussions with my client.
Okay. Do you plan on filing a motion regardless? If it comes back that she's not willing to drop the case, are there motions that you plan on filing prior to going to trial?
Oh, no, Judge. I just argued that at trial. I was just simply suggesting that if the court didn't want to put it on a final plea calendar, I was just trying to create an alternative. That's all.
Well, I guess what I really want to do is we're already on a final plea calendar.
Right.
Nothing's happened since the last time that you were here in that regard. I need something to happen, be put on a final plea calendar. What's the point of having a final plea calendar? So I'm going to put it on a jury trial calendar.
Okay.
So that if you can't work it out, then the next step would be trial, right?
That's good. That's
All
good,
right.
Judge.
So the October trial calendar.
and Your Honor, I do not see any notes from Ms. Reiser regarding any further investigation, but that doesn't mean that that's not occurring. She just may not have put it in the system.
Okay, thank you, Ms. Riley. So for now, unless there's anything further with Mr. Alexander, is he free to go?
He's free to go. And for the record, just to be fair, Ms. Reiser, when she sent me the email, she had a ton of cases that her and I were working on. And so I'm not suggesting that she's not working on it. Well, matter of fact, I'm saying she is working on it. She probably just didn't have time to put the note in. I just want to be fair to Ms. Reiser.
Okay, I don't think anyone took it that way.
Okay.
Your client has his hand up. You want to talk to me? Mr. Alexander, let me say, you have a right to remain silent. Anything you say can be used against you. Talk to Mr. Gaither, and if Mr. Gaither wants you to talk to me, then I'm happy to talk to you, okay? Yes, ma'am. What's your name?
I just wanted to say that I'm Kirsten Alterman and I am present at court. You called my name, but my attorney.
Okay.
answered for me, so I'm here.
Okay, we're happy to have you, ma'am. Thank you. Sean,
That's Ms. Helens. I think she made an announcement on that, Judge.
okay, if you'll just hang tight for us, Ms. Harshaw. Ms. Helen will be speaking with the solicitor regarding your case. Ms. Harshaw is in the courtroom with me. You with me, Ms. Helen? Okay. All right, anyone else in court? Yes, sir.
Have you called my client, Mr. Ian Dalatka?
Yes.
I've completed the DocuSign plea paperwork. It is a first offender plea. That's not mentioned in the paperwork. I do have an email from Ms. Reiser though saying, confirming it is. So I just didn't know if that needs to be added or how that works.
Okay. Did you get that, Ms. Riley?
Yes, Your Honor. However, at which position are we speaking?
I believe this is position number 6. Is it Dow?
Ian Dalatka.
Yes.
Okay, yes. I do have a note from Ms. Reiser that there's no objection to first offender.
Okay, and do we already have the paperwork?
We've done the DocuSign paperwork. We just completed that about 5 minutes ago.
Okay, so as soon as the court gets that, then I'm happy to go ahead and take that plea.
Thank you, Judge.
And Your Honor, I'm not sure if Mr. Haddad is in the courtroom or not. Mr. Haddad, on Mr. Dawaleka's second case or first case, that's in diversion, I do indicate that it has been completed and that a no pros has been submitted to the litigation manager. It just doesn't tell me which litigation manager.
All right, great. Thank you. Thank you, Mr. Riley.
You're welcome.
Okay, let's see, Ms. Riley, I want to go ahead and take, you have something, Mr.?
Just an announcement on Mr. Reed, position either 16 or 17. We have different calendars apparently. Bench trials for Mr. Reed.
I'm sorry, say it again.
We wanted a bench trial. I've conferred with my client Coleman Reeds, and he indicated a bench trial in lieu of
Okay.
jury trial.
All right, position 16, Coleman Reed, bench trial will be on October 18th.
Thank you, Judge. And of course, the 1:30 calendar on the 18th.
The bench trials will be at 1:30, yes.
And can my client be excused, Judge?
Yes.
All right, thank you.
Have a good afternoon, Mr. Coleman. We'll see you back. And just for the record, there is no objection from the state. Is that correct, Ms. McCutcheon, on a bench trial? I'll make sure to get that on the record for you.
Sure, Judge.
So I'm gonna, Ms. Riley, we'll go ahead and we'll take this plea, after which,
I need to conference with Attorney Shair as well as Attorney Stinson.
okay, and do you have Attorney Shair's phone number?
I do not.
Okay, so if you can provide that to us, we'll put it into the chat, and as soon as we take this plea. Yes, that's fine. Okay, if you all will come to the podium, counsel? No. Yes.
Your Honor, as they're coming to the podium, just revisiting that Orca status calendar from this morning, number 14, when Ms. Hurd is present. Did we reset that for October the 4th? So I can release her?
Tell me again, I'm sorry.
I'm sorry.
Which position?
Position 14 on the Orca status calendar from this morning.
Okay, yes, and what's the request?
Look for that October the 4th final plea date.
Okay,
Okay.
October.
That's my client now. Or is October the 4th? No, October the 4th is full, right?
No.
Gotcha. Okay.
All right, yes, and Ms. Hurd, you're free to go. We'll see you back then.
Okay.
And Judge, that was originally a bench warrant, so now it's an October 4th. Okay,
Correct.
okay, thank you.
And Ms. McCutcheon, while you're back with me, I don't know if you heard, but on position Position 16, Coleman Reed. Mr. Reed did request a bench trial, and I just wanted to make sure that there was no objection from the state on the record.
No objection, Your Honor.
Okay, thank you.
And I believe Ms. Helen wanted to speak with me, Judge. While you're taking the plea, I can speak with Ms. Helen if she still wanted to speak with me.
Okay, thank you. Ms. Helen, are you with us?
Yes, Judge, that'd be great if I can give her a call or breakout, however would be best for the court.
We can do a breakout. That's fine. So we can put Ms. McCutcheon and Ms. Helen into a breakout room.
You too.
Good afternoon, Mr. Delacour. I'm Judge Eric Morrow. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down. Thank you. Ms. Riley?
Thank you, Your Honor. The state would expect the evidence to show that on April 14th of 2021, officers were dispatched to an address in Johns Creek, Fulton County. The reporting party stated that there was an altercation, which was the defendant, altercation with his sister. And he was then attacked by his father. Officers spoke with all parties involved, and one being the father, and stated that his son had assaulted his daughter, and that there was a video to that effect. After viewing the video, the officers determined Mr. Dawakaf to be the primary aggressor and charged with simple battery, family violence. The state's recommendation in this case is 12 months probation, 12 anger management classes, and the state does not have an objection to Mr. Dawakaf using his first offender.
Okay. Counsel.
Judge, good afternoon. Tom Nagel on his behalf. This is a negotiated plea, Judge. We are tendering under the first offender statute, and we're asking Your Honor to sentence him also under the provision of OCGA 42-8-62-1, which would restrict and seal the sentence when it's entered.
Okay. Any objections, Riley?
Your Honor, the state would not have an objection.
Okay. Anything further, counsel?
No, Your Honor.
Mr. Jolicoeur, it's my understanding that in case 21 CR 001890F, you wish to plead guilty to simple battery family violence. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this
No.
time? You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Given that it will terminate when you complete the anger management classes, the sooner you get those completed, the sooner you won't be on probation, and the sooner you won't have to pay those fees. So the sooner you get it done, the sooner you have all this behind you. Okay.
Okay, thank you.
Nothing further. I'll sign that. Those documents, I will give you where you need to go to report to probation. I ask that you report within the next 2 weeks or so. Anything further?
Your Honor, from the state, respectfully, I believe that with the use of first offender, probation does have to be for the full 12 months in order to be eligible to use first offender. They have to successfully complete the 12 months on probation with no infractions for first offender.
Does it have to be reporting probation, or can it be non-reporting probation?
It can be non-reporting, but he just would have to remain on probation. the
Okay,
entire
so
time.
is that agreeable, counsel?
I'm not familiar with that, Judge. I've been practicing 30 years. I know that, the negotiated plea was that it would terminate once he completes the terms and conditions. So I'm not familiar with that. It has to be a full year for that to be effective. I don't know if,
I don't know. I mean, I understand that not being on probation is preferable to being on non-reporting probation, but if it's non-reporting and he's still not going to have to pay the fees, and it would go non-reporting as soon as he completes.
He's seeking to be restricted.
yeah, that's what he said. Well, that's what he said.
From the
Well,
start.
that's what we asked for.
Okay.
Judge, if the court is going to enter the plea under the 42-8-62-1, then we wouldn't have a problem with that.
Okay, and so may I, on this, is that on the sheet, may I put non-reporting upon completion as opposed to termination? Is that agreeable with those?
There's no objection.
No objection from the state, Your Honor.
All right. Okay, anything further? Okay, if not, we will get you the that information. And once you complete it, you are free to go. Thank you.
Judge.
Okay. Any other announcements at the present time?
Probation sheet. Thank you.
And Your Honor, if there are no other pleas for me to take at this time, I will go offline to call Attorney Shire.
Okay, thank you.
Thank you.
The only update is that I forwarded the paperwork on position number 15 to Ms. McCutcheon, Alterman.
Okay. Oh, okay, that's fine. Ms. McCutcheon, are there any, others that you need to speak with at the present time?
I don't believe so. I spoke with Miss Helen. We just spoke about her two cases. Mr. Gaither, is he still in the courtroom?
No, he's not.
Okay, and I don't think he and I had anything to discuss with. I'll just share with him via email the information I found on the second case he was inquiring about
Okay.
regarding his client. I don't believe, Mr. Haddad, you didn't need to speak with me, correct, sir?
No, I just forwarded you the plea paperwork on position
All righty.
16 or 15. For
Okay.
whatever reason, Judge, we have different numbers.
Our calendar, Miss Helen had the same calendar that I have. Our numbers are one off from the judge's calendar, apparently.
It is. There was initially a duplicate. That's the reason there's one off. And Judge, I have announcements on position 12 and 13, whatever the court's ready.
Okay, I'm ready.
Judge, for both positions, we're going to ask for a reset for Ms. Harshaw. I think the state is going to get a transcript from a warrant hearing application because there may not be a police body worn camera available or a warrant because the police may not have been called out. So we're asking for a reset just so I can get that application, or excuse me, the transcript of that warrant hearing application.
And Judge, the state has already requested that. There seems to be some dispute as to what was alleged in the warrant and the charges that are before the court, and the state wants to make certain that the allegation that's in the warrant, whether or not that in fact was testified to at the hearing. Because if so, it would involve the allegation of a firearm. And so we'd ask respectfully that that be reset so that we can obtain that.
Okay, so the final plea calendar on September 6th. So that's going to give you enough time?
I believe so, Your Honor.
Yes, Judge.
That is at 1:30.
1:30.
Okay, so that's Miss Harshaw. Yes, ma'am.
So like I had stated before, Judge, I'm due in just a few weeks here. So September 6th, would probably not be good for me for that day. I'm probably 33 weeks.
Okay, I understand, ma'am. Ms. Helen, your client is due around that time, so I'm going to push it back.
Yes, Your Judge, please.
You all instead of September, October 4th. Is that better?
Yeah.
When do you do, ma'am?
I'm sorry.
I said, when are you due?
Originally it was the 24th, but due to some medical issues I'm having, he's thinking the 6th or the 7th. I will find out definitely on Monday.
Okay, so I'm just want to make sure I'm giving you enough time. Okay, so October 4th. Okay. All right. Thank you, ma'am.
Thank you, Judge.
Free to go?
Yes.
Okay, you're free to go, Ms. Harshaw. And we're gonna make an announcement on what, Tierra Jones?
Yes, Your Honor. We're asking for that reset. Again, I spoke with the state. The videos have been requested. They just have not received them. As soon as they receive them, they'll send them to me. And I just want to review those videos with Ms. Jones, but I do believe we will have a resolution to this, Judge.
Okay, October 4th, final plea date.
Yes, Judge.
Okay. Did Ms. Jones join us this afternoon, Ms. Helen?
I thought that she was appearing in person, Judge. If you can give me I spoke to her, if you give me an opportunity just to.
Right, can you raise her? Because I'm not sure why she's not with us today.
Yes, Judge, just give me an opportunity to raise Ms. Jones
Okay.
here. And give her a call.
Okay. Any other announcements at present?
Judge, we just wanted to talk with Ms. McCutcheon to just clarify the plea, and if it's good, we'll go forward. If not, we may do a non-negotiated plea with your honor.
Okay, Ms. McCutcheon, counsel would like to speak with you. Can we get your, can we put your, do you have her number?
Ms. McCutcheon, no, I don't.
Okay, would you like us to put your number in the chat so she can call you?
Yes.
Okay, so why don't you get it to the clerk and we'll send her a message. Okay, Ms. McCutcheon?
Yeah, that's fine, Judge. Mhm.
Thank you.
And Your Honor, I have spoken with Attorney Shayer. I'm not sure if he's back in the courtroom yet. But I am working on the plea paperwork for him, but I would need to go into a breakout room with Attorney Stinson.
Okay, so we'll work on that paperwork and let's see. Is Mr. Stinson on with us?
Yes, Judge, I'm here.
Okay, so we're gonna put you in a breakout room with Ms. Riley, Mr. Stinson. So if we can put Ms. Riley and Mr. Stinson in a breakout room, please.
Thank you, Judge.
Okay, so Ms. McCutcheon will be speaking with counsel. Ms. Riley will be speaking with
Yes, Judge.
counsel. And so I'm just, we'll, until you all come back, we will be in recess. Thank you.
Thank you, Judge. Mhm. And Mr. Haddad, I'm sending this back to you. The plea paperwork.
And Judge, I'm ready on position 13, my calendar 13, Ms. Tierra Jones.
Yes, Ms.
And Judge,
Howard.
I just spoke to Ms. Jones. I apologize for cutting you off, but she appeared in court. I think that there was some confusion and she left, but she did appear in court, Judge. So she is now present on the Zoom call.
Okay, no, I just wanted to make sure that she was here and that she knew what we had. If she was here, I don't remember releasing her, but I just wanted to make sure that she knew that I'd see her back on October 4th for that final plea calendar, okay?
Understood, Judge.
All right, have a good rest of your day, Ms. Jones.
Thank you, Judge.
You're welcome.
Thank you, Judge.
Is there an announcement?
Yes, Judge, we're going to announce ready for trial. You can put us on the October 4th jury trial,
Okay.
or the October jury trial calendar, rather.
Position number 7, is that right, Mr. Apikwa?
Yes.
Okay, October jury trial, you will get notification of that trial. So we'll see you back in October.
Thank you, Judge. May we be excused?
Yes, have a good rest of your day. Thank you.
You do.
Your Honor, I did speak with counsel on position number 14. I believe it's the court's number 15. Mr. Lee, Preston Lee, 21CR 002977F. It actually would have been a position that Ms. Riley would handle, but it's still all the state's cases. I reiterated the most recent offer that ASG Riser had communicated, and the state's position is that is the most recent offer and therefore the valid offer, since the prior offer was not accepted. And so I believe Mr. Opposing counsel has an announcement for the court that it may be a non-negotiated plea. Mr. Awad, are you back? Okay.
Yes, I'm here. Yes, Judge.
Okay, I'm sorry. Tell me, what's the name? The client?
Preston Lee.
Mr. Lee.
We believe it's
Okay.
15 on your calendar, Judge.
Okay.
13.
All right. So, are we ready for the? It's going to be a non-negotiated plea.
Judge.
Okay. And has the paperwork been completed?
Not yet, Judge, but
Okay.
we'll get it ready for you.
All right. So get the paperwork ready, and I'm happy to take it.
Do you have paperwork, Mr. Awad?
No, we do not.
Okay, because and Judge, of course, as I said on my end, I'm having problems. If Miss Riley is available. Miss Riley, are
I
you
think
available?
she's in a, she was in a breakout room or speaking with someone.
Miss Riley, I know this is the day, this is the day. And Judge, we apologize to the court. Both Miss Riley and I had some recent updates on our laptops. And of course, you know, Murphy's Law, the updates seem to have fixed some things, but then interfere with other things. So we're having problems with paperwork. Position number 14, I just pre-tried with the attorney, Miss Riley, and reiterated the most recent offer that Ms. Riser communicated to him, which by the state's position is the most valid offer because it's the most recent. Okay. But I do not have plea paperwork. It's going to be non-negotiated and I can't draft plea paperwork. Are you able to send that?
We have some plea paperwork here, I'm told. So we can get that to counsel if that's all right with everybody.
Yes, Judge, and it's non-negotiated. He's indicated.
Okay, right. So let's get him the plea paperwork, and once you complete it, let me know and we'll move forward. Okay. I don't have pretrial on the line with me to give me your client's history. Would you like me to get someone from pretrial here to give me the history, or will you accept that history from the state?
I'll accept it from the state.
Okay, thank you. So before we take that plea, if you all can make sure that you have Preston Lee's history for me.
Thank you.
Okay, all right, so just let me know when you're ready
Yes, Judge.
and we'll get you that paperwork.
He keeps saying that there's.
Ms. McCutcheon, will your office be in training again tomorrow?
Yes, Judge, this is a 3 days training.
Okay, thank you.
So Ms. Riley, will you be here tomorrow, Your Honor?
I will be, yes.
So it'll be Ms. Riley and I again.
Okay, well, it's always a pleasure.
Yes. And Judge, I was on Teams, the county teams on a call with our IT trying to rectify my issues. As soon as we finish today, I'll get back on a face-to-face Teams call and allow IT to access my computer and see if they can fix whatever's going on. We didn't have time to do it over the lunch break. We tried, but we ran out of time. So we're still working on it, Judge.
Okay, thank you.
All right, is Your Honor handling the morning and afternoon calendars, Judge?
I am, yes.
Okay.
Ms. Clemens, did you need me for something? Guess not.
Good afternoon, Judge. How are you?
Hi, I'm doing well. I saw you there.
Yes, could I be placed in a breakout room with Ms. McCutcheon and Ms. Ari Young? She's the victim of the Preston Lee case. She had some questions.
Okay, is that fine with you, Ms. McCutcheon?
Riley, do you want me to go into the breakout room or would you prefer to go? It's position number 14.
I don't have position 14, but.
Oh, I had position 14. I'm
yes,
sorry.
no
That's
problem.
right. That's
Okay.
why I pre-tried with counsel. I had position 14. Yes,
Okay.
we can go to the breakout room, Ms. Clemens. I apologize.
No problem.
Okay, so if we can place them in a breakout room for the court, thank you. Counsel, are we waiting on paperwork for your
Yes,
case?
waiting on paperwork. I know Ms.
Okay.
Riley said she sent it this morning.
Okay, all right. So, well, as soon as we can.
Yes, thank you for your patience. I'm working on it now.
I appreciate it.
You're welcome.
We don't know yet. They would promise you.
It's really pretty.
Yes.
Turn off and then start it up. Mm-mm. Mm-mm. Mm-mm.
Yeah, approach judge?
Yes. Thank you. And Ms. McCutcheon's in a breakout room right now, so as soon as she comes back, we'll get her taken. Thank you.
And I should have a plea with Ms. McCutcheon as well, Judge.
Yes, I have that. Yes, for that. Counsel, the charge is that he's going to plead to his criminal trespass and damage to property. Is that right?
That's correct, Judge.
Okay, you don't have that listed on the charge here. May I write it on here?
Yes, Judge.
Okay.
Thank you.
Ms. McCutcheon, if you're ready, I have two pleas of yours that we can take. That's okay with you?
Yes, Judge. Can we do Mr. Preston Lee? I believe it's number 15 on the court's calendar because we have the victim who's here. She's on Zoom. If we can take care of that one, that's Mr.
Yes.
Awad. Mr. Awad was completing the paperwork in the courtroom.
I have it, yes.
Okay. And that's one count of criminal trespass, misdemeanor criminal trespass, damage to property.
That's correct.
The state had made a recommendation. Ms. Reiser's recommendation that was communicated to defense counsel was 12 months probation, for $235 restitution for damaged items, and that the defendant complete the family violence intervention program, and that he have no further contact whatsoever with Ari Young, who is the ex-wife of the defendant. And I know, Your Honor, you had, and that is Mr. Awad, on behalf of the defendant, has rejected that plea offer. And so this would now be a non-negotiated plea. And I know the court had inquired about the defendant's criminal history. And I'm looking at that criminal history now, Your Honor. He had a prior simple assault, a prior domestic violence case, simple assault, that was dismissed. And that was in Pierce County, and that was back in 2014. And as I said, that was a domestic violence offense. I show I'm still looking, Judge. And that was an out-of-state offense. But in Georgia, I show he had a 2012 not presented to the grand jury. That was a larceny count. And then he has an uttering bad checks. And that is all that I show, Judge. And then the instant case that is before the court.
Okay. Can you give me the facts, please?
Yes, Judge. Okay, if this case had gone to trial, the state would expect the evidence in this case to show, Your Honor, that on the incident date, when officers responded on June 22nd of 2021, in reference to a call of damage to property at a location in Fulton County, Alpharetta, Georgia, at 5101 Beaver Creek Road. The officer indicated that he or she had previously been at this address for a civil dispute where Ms. Ari Young, the victim, first name A-R-Y, last name Young, common spelling, wanted to remove her belongings from the apartment that she shared with her husband, the named defendant, Preston Lee. At that time of when officers respond, there was no crime was known to have been committed. Officers returned to the scene on that date and observed several of Ms. Young's belongings had been damaged, allegedly by Mr. Lee, believed to have been damaged by Mr. Lee. Those included 3 sets of rosary beads at a value of $150, a vanity sign written at approximately $20, a vanity sign, and then a sign with a rainbow and a snow globe. The value of these items being less than $500. The damage was visible to the items. Ms. Young stated that she believed there were other items, but she did not provide the list of any other items. So at this time, the state has alleged the damage to have been the items that I just described to the court, the rosary beads and the signs. They were legally married and shared the apartment at that incident location. However, the state would expect that Ms. Young would testify to the court today that the two are currently divorced. So although this is a criminal trespass charge, Your Honor, it is domestic violence in nature as to the relationship of the two at the time that the offense occurred. The state's original offer included family violence intervention program. It's my understanding from pre-trying the case with Mr. Awad that previously an assistant solicitor had indicated anger management. However, that offer was never accepted. And so the most recent offer that ASG Riser communicated to counsel included not anger management, but family violence intervention counseling, the 6-month program, as well as the restitution based on the relationship of the parties.
Okay. Anything further? Ms. McCutcheon?
Not for myself, Your Honor, but before the court imposes sentencing, Ms. Young would like to speak to the court if the court would allow. She's present on the Zoom.
Okay. Good afternoon, Ms. Young. You'll have to unmute yourself, raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. Thank you, ma'am. What would you like to tell the court?
Yeah, I would just like to share with the court that I was married to Mr. Preston Lee. We were together, I guess, for a total of about 3.5 years. And during that time, there were multiple incidents, but of course, this is the only one we're looking at today due to the police involvement. One thing that I'm not sure if the assistant solicitor mentioned is that the reason there was an arrest is when we discovered the property damage, which the list is not extensive, but that's not my main concern. My priority is making sure that I and other victims have hopefully a little bit of justice and that maybe other victims are prevented and that people are safer in our community. But when we found the property damage and the police returned, they had asked him to stay away. He knew I was in the residence and he did attempt to break through the door, which is where the other charge or the other part of the police report and what actually I believe led to the arrest is because a policeman was inside the apartment with me when he attempted to come back through the door in a very loud and aggressive way. And I do have a witness present with me who was there at that time and witnessed all of what I'm saying. But yes, it was a very difficult relationship. And since I am not the only person who has experienced similar things from him, I would really like to ask the court to do whatever possible to ensure there is accountability and some justice. Thank you.
And Your Honor, respectfully, Your Honor, when I was reading the recitation of the criminal history, I failed to inform the court that although the defendant had a DeKalb County 2014 battery, family violence that was dismissed, he does have an obstruction of law enforcement officer plea from conviction from 2014 out of DeKalb County, obstruction of a law enforcement officer misdemeanor.
Okay, and Ms. McCutcheon, do you have there whether or not, how much time Mr. Lee spent in custody?
On this case, Judge, let me check, Judge, to see if he was actually booked. This happened in Alpharetta, so I don't know if he was taken to the North Annex or to Fulton County Rice Street, but I will check, Judge.
Thank you. Okay, good afternoon, Mr. Lee.
Good afternoon, Your Honor.
Can you raise your right hand for me?
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can put your hand down. Thank you. Counsel.
Yes, Judge. Mainly the facts are uncontested. On 6/21/21, Mr. Lee was in his home with Ms. Ari Young. They had an argument. And to his credit, Mr. Lee said, either you leave or I leave. And she says, no, you should leave. And he does. He leaves. Then she calls him and says, you can come back. My friends have picked me up. So he comes back to the home. Nobody's in the home. He learns that she was cheating on him with another woman. He's upset. He throws some objects and breaks them. No one is contesting that. The value of the objects are $235. No one was there when he broke these items. He did not throw them against someone. He didn't put anyone in danger. And the next day, the police officers come just to help Miss Ari Young pick up items from her house. That's, as was disclosed, it was discovered that he broke some items. So at no time was Miss Young in danger. And that's uncontested. Mr. Lee is here to be accountable for the allegations, for what he did. The original recommendation was him to plead guilty to the offense, be in anger management for 8 weeks, do a drug and alcohol evaluation with any recommended treatment. And we thought that was fair. We thought that was a fair exchange for the guilty plea. However, when I asked Ms. Githiea whether or not he would be eligible for diversion, the plea then changed to $7,000 in restitution. $7,000. And that's when I asked, what's the justification for $7,000 in restitution? She said she was going to send me medical records of how this affected Miss Young. She never sent me those records. And then the offer changed. So I never accepted the offer or rejected the offer. I merely inquired about diversion. Now it's a 26-week program of family violence intervention, which we think is an unfair consequence, seeing that an 8-week anger management course is more than enough for him to work on his responses and his reaction. Getting upset like that, it's not warranted for him to break anything, let alone property that's not his. So we just want to be very clear that when Ms. Young says we don't want anyone to be hurt or victimized by Mr. Lee, that was not the case. What did occur was property was damaged, wrongfully so, but no one was hurt. No one was in apprehension of fear or anything like that. So he is here to accept responsibility for what he did, but we would ask the court to enforce a more suitable sentence.
And what was the idea behind the alcohol evaluation?
Because he had been drinking. When he broke those items, he was drinking at that time. So that had to deal that, that caused that eruption or had to do with that eruption. So a drug and alcohol evaluation was appropriate because we don't want him to have those type of outbursts. Those are not appropriate outbursts. So in that negotiation, that was the idea until it became $7,000 of restitution, and then the plea negotiations fell apart.
Anything further?
You want to say anything?
Yes, I'd like to say something, Your Honor.
Go ahead.
Okay, just let me, let me make it clear that I haven't sentenced you yet, and anything you say may be used against you, but if you would like to address the board, I'm happy to hear you.
Absolutely.
Okay.
Yes, Your Honor. Thank
Okay.
you. Yeah, my name is Preston Lee. I am ready and able to accept what you deem appropriate for me, Your Honor. I am a veteran of the United States with diagnosed PTSD. I do go to treatments for that. I go Tuesdays and Thursday nights to the National PTSD Foundation, and I do Alcoholics Anonymous, sir. It's been a struggle for me for many years. So I just wanted that to be known. And the only reason that I went back to the apartment here was to get my service dog, Frank, was in the apartment and I forgot him. And she had him for 5 weeks and I had to get an attorney to get my dog back. So that was the only reason I went back to that apartment. Thanks.
Anything further?
No, sir. No, Your Honor.
Ms. McCutcheon? anything
Yes,
further?
Your Honor. Yeah, just to clarify to the court, Your Honor, I don't know what counsel was referring to regarding the offer and the offer changing when he inquired about diversion, but I will make the court aware that based on my breakout conversation with Ms. Young, whom I met for the first time today, I explained to Ms. Young that even though she has indicated to me that she has gone through some treatment, medical treatment, counseling type treatment because of her relationship with the defendant, as she has alleged, I explained to her that we cannot request those types of expenses in restitution. So I don't know if that was probably one of the issues that Ms. Githia had presented to counsel, but I explained to Ms. Young that we cannot request that in restitution from the court, which is why we are requesting the $235 in restitution for the broken personal items. Additionally, the court inquired as to the jail time, and according to the Fulton County Jail booking information, the defendant spent 1 day in custody.
Okay. Anything further, Ms. McCutcheon or Ms. Young? I saw that she had her hand up a moment ago.
Yes, sir. I just wanted to clarify, Your Honor, that some of the information that was just given actually was incorrect. For the record, I would like to state that I left the apartment of my own accord the night before the arrest. One of my friends who was here with me as support, as well as other friends, were involved in coming to pick me up in the middle of the night because I reached out to them. I had received text messages, which are still in my possession, that I was threatened with physical aggression, threatened to be hit via text message, which I do have in my possession. That's why I left. That was the night before. Due to his military combat training and the way in which I had personally known of and seen him use that at times, I had personally inquired the police to come. So the statement that I was there that day leading up to the breaking of my items and the arrest, unfortunately, many items which are sentimental in nature, gifts from my parents who are no longer in the picture, family items, things from trips to Africa when I did missions work over there. All of those things are items that cannot be justified with amounts, but I was not there, Your Honor. I actually sought to leave for my own safety. I left our 3 pets behind, and the only reason I had his service it's not a service dog, it's like an emotional support animal, is because he went to jail and someone needed to take care of the animal. And while we were going through the restraining order process until everything was sorted out, I kept all of the family dogs. 2 of the pets I still have in my possession, even though one of them prior belonged to him. So I just wanted to clarify a couple of things, that it was not out of malice that I had one of the dogs that is his ESA, and that I was not there leading up to when all this happened. I had already left. And when I left the apartment, nothing was damaged, nothing was broken. It was out of fear for my life and my safety. Thank you.
Anything further, counsel?
Judge, I do have one post that I wanted to share. There's a lot of posts and text messages, but I think one is appropriate to share that kind of sheds light on the credibility of Miss Young. If I can approach Judge.
We don't have it.
I'll wait for show of close counsel.
Right, Judge, I'd like to know what it is that counsel wants to show to the court and what it is purporting,
It's
the origin and the contents.
It's a Facebook post that Miss Young made regarding this incident and what she was going to do about it. It's fairly notable what she intended to do. And so here she is making mention of a lot of things that she was subjected to. And I think this post sheds some light as to her credibility.
Well, Your Honor, I'd ask the court to only consider this if it is relevant to what happened on the date of this incident date, and the items that were alleged to have been broken. The defendant is charged in the criminal trespass accusation with having broken specific items on the incident date of June 21st of 2021. Although Ms. Ari Young has testified to the court and alluded to other prior difficulties with the defendant, we're asking the court, other than the criminal history that the state presented to the defendant, other than the victim's representation to the court that she is fearful of the defendant, and therefore that would justify the state's recommendation of no further contact. Anything that counsel has that is outside the 4 corners of what this defendant is charged with today, Judge, we'd ask the court not to consider that.
Okay. I agree with you, Ms. McCutcheon. I allowed Ms. Young to tell me everything that she needed to tell me. A lot of it was outside of the scope of this criminal trespass and damage to property. Let me tell you, counsel, that I'm only considering the criminal damage, criminal trespass and damage to property charge. So whatever, all the other allegations that went on before, I've only got to have this charge, and I think I understand what's going. There's animosity. I understand that. So, although I did allow Ms. Young to go on, and there was no objection to it, there was an objection to this, but I think I understand what you all have presented. Okay.
Thank you, Judge.
Anything further before I take the plea?
No, Judge.
Anyone?
No, Judge.
All right. And you are under oath, Mr. Lee. It's my understanding that in case 21 CR 002977F, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury.
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No.
And you did have the opportunity to go through the plea sheet line by line, is that right?
Yes, Your Honor.
And you signed it at the bottom?
Yes, sir.
And you give this plea freely and voluntarily with full understanding of the charge against you?
Yes, Your Honor.
Okay, I will accept your plea, Mr. Lee. The court sentence is going to be 12 months to serve 1 day, credit for time served 1 day. The balance is going to be probated. 12 weeks of anger management, alcohol, drug evaluation and treatment, no further contact with Ari Young, and no drugs, alcohol, or weapons while you're on probation.
Yes,
given that this is a 2021 case, when you complete the terms of the probation, it'll go to a non-reporting status. You'll still be on probation, but you won't have to report. Let me just make it clear for Ms. Young and for yourself, but no further contact means. And I don't know if you all have been in contact since 2021 or not, but no contact means absolutely no contact. No, obviously no personal contact, no phone contact, no internet contact, no social media contact, no contact whatsoever. If there's any contact, then you'd be in violation and it's subject to your probation being revoked. Okay, we will give you where you need to report to probation. I'll ask that you report within the next 2 weeks or so.
Yes, sir.
Okay, are we clear? Any questions?
No questions. Thank you, Judge.
All right, good luck to you, Mr. Lee.
Yes, sir.
Good luck to you also, Ms. Young.
Should we wait until we sign up with probation?
Yes, we'll get you the paperwork.
Thank you, Judge.
Let's see. The next in line, I think, is Alterman. Good afternoon, Ms. Altman. Thank you for your patience today. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. You can put your hand down. Yes, Ms. McCutcheon. I'm sorry, Miss, you're on mute.
Apologize, Your Honor.
It's
Yes.
fine.
The state would expect the defendant in this case is charged with battery, family violence, and cruelty to children in the third degree alleged to have occurred on July the 19th of 2021. Had the case gone to trial, the state would expect the evidence to show that on the date as alleged, officers responded to the Fulton County location at 571 Willow Heights Drive, Sandy Springs, Fulton County, made contact with the complainant in reference to an assault call. A mother on the scene was alleged to have been assaulting her female daughter. Wait 1 minute, Judge. This
Judge,
is
I can stipulate to the facts,
Yes.
Judge.
yeah. Will you stipulate to the factual basis then, counsel,
Yes.
for battery, family violence, and cruelty to children? Yes.
Yes, Judge. It's a little bit more convoluted, but
Yes.
we do stipulate that there's sufficient evidence. I'm sorry, Judge, that there's sufficient evidence for the state to prove their case against my client. We are requesting, so I stipulate the facts, the venue. We are requesting first offender treatment. My client is eligible, Judge. I probably have spent more time on this case than most other cases, Judge, and I've had lots of conversation with Ms. Reiser back and forth, and of course with my clients. This is a good resolution to the case. The only request I have, and I know that I understand the court's position, but my client's going through transitional issues with housing, et cetera. If the court anyway can as far as the probation fees, perhaps waive the first couple of months or 3 months, anything to help. The negotiated plea is 12 anger management classes. She has to attend AA. Now, I would want to point out that my client has, after she got out of custody, she's really done so much to better herself mentally and physically, Judge. She's gone to AA meetings. She's done counseling. But anyway, the negotiated plea is spelled out in the plea sheet. It's accurate. My client would like to request non-reporting once everything's complete. I understand, it's up to the court, of course, but other than that, Judge, this is a very emotional thing for my client. I really wanted an in-person plea. I think it is more appropriate in this case. It's taken a lot to get here. And I appreciate Ms. Reiser working with me to work out the details, Judge. I think referenced this in the past. There's, I'll leave it. There's a lengthy and I can't say the word now. The parties don't get along, and I think a stay away is great. It's a good idea. The state, I believe, was going to null pros count 2, so my client is entering a plea on count 1, which is the family violence, where the alleged victim or the victim is her mother.
Well, counsel, yes, and Judge, I was very careful because we were in open court. I'm on Zoom, but I know the counsel and defendant are in open court, and so of course, not to violate any communications that should not be made in a public forum. However, Mr. Haddad, I do not have any indication that Ms. Reiser had agreed to a first offender, which is very atypical, and I did not expect that unless Ms. Riley has some more recent communication regarding this battery family violence. And Judge, as I said, I did not want to go into the scope of some of the conditions that were alleged, but the factual basis is that it's a dispute, a physical confrontation from the defendant allegedly against her daughter, who is the named victim, where she is alleged to have slapped the victim, her daughter, Carla Alterman, in the presence of the grandchildren.
It's the opposite. The Carla is the mother of my client.
I think she's saying like daughter, but me.
So was Carla the one that was on those?
Yes, Judge. Yeah, she's the mother.
So
it wasn't
mother and Miss Alterman's the daughter.
That's
yes,
correct.
Judge. Yes, that's correct, Judge. I misspoke. It's a mother-daughter relationship, and there were grandchildren present during the incident.
And it's Miss Alterman's children.
That's correct, Judge.
My babies.
Okay, so Ms. Riley, I see that you appeared. Did you have any input about the first offender?
I'm sorry, I did not. I came in on the tail end of that. I was talking to Attorney Rockwell, but I believe we have a similar situation coming up with one of our pleas. If it is a family violence, there is the state objects to first offender, the use of first offender on those types of offenses.
And Judge, in all honesty, Judge, I spoke to Ms. Reiser about it. What I had mentioned is that we're going to request first offender. Ms. Reiser said she's eligible, and I did not write down that Ms. Reiser said she consents to it. I'm not trying to say that. She did not put in an email. But I did mention to Ms. Reiser, and I think frankly, when I mentioned that she's eligible, that was the end of the conversation. And I'm familiar with the state's position.
So she's eligible, so she doesn't have a history of any.
Right, that's correct, Judge. And I mentioned in an email to Ms. McCutcheon because that was going to be my request, and I did not mean to say that Ms. Reiser has consented. I know the state's policy, and I would have remembered specifically if Ms. Reiser told me, yes, I agree with it. That's never been proposed to me. Under these circumstances, Judge, and if I can be heard as far as first offender, I mean, my client was born in, I think, 1972. So I mean, she doesn't have a record, criminal history record, convictions. There's a lot to this case than just what transpired that day. My client is employed. Actually, she lost her job because of this. She's trying to get her life, her things back on her feet, so to speak, with work. There's a lot of family dynamics, including the children, my client's adult children now. And I'm just trying to get her as much of a break as I can. The first offender is important to her, and that's why I would request that, Judge. And I understand the state's policies normally, but in light of this case, Judge, it's just relatively unusual than your more typical domestic, whether spousal abuse or alleged spousal abuse, things along those lines, Judge. Okay.
And actually, counsel, respectively, I know Mr. Jawan Haddad did indicate in his email he was requesting it, and I thought perhaps that that you were indicating this was part of the negotiation, and I was not aware of that. But I know you did indicate that you had requested it, but you did not say per se that Ms. Reiser had agreed. But I wanted to make that clear because I did not have any indication. And although I don't show any convictions for the defendant, I do show some arrests. There is a DUI that's showing on the criminal history, and there's no disposition of that. So I do not know what, in fact, was the resolution of the DUI that shows on the criminal history counsel. So at this point, Judge, notwithstanding the fact that we are opposed to a first offender on a domestic violence battery family violence, but also the fact that there is a charge from 1991 that I do not know the disposition of.
And just so that I'm clear, the state's recommendation was for the battery family violence, 12 months probation, 12 anger management classes, mental health treatment, to submit monthly reports from a doctor, 1 AA meeting per week, no further contact with the victim, and reporting probation 12 months.
Correct, Judge.
That's what you all agreed to?
Yes, Judge, I think my client sitting in to the prior plea where was requesting non-reporting probation. I think that's where that comes from. But the plea offer is the recommendation. What we had agreed on is what's stated in the plea sheet, Judge. The only deviation, two deviations. One is the probation fee request waiver, and that number two was my request for first offender treatment, Judge.
And the state's opposed to both the first offender and the non-reporting after a certain period of time. We would want reporting in its entirety based on the circumstances and factual basis of this case, Judge.
And the cruelty to children, that's being all processed.
That was the agreement with Ms. Reiser that I had. It was the plea recommendation in the document, the DocuSign that I never filled out, only referenced count 1, family violence battery. So I took that as based on our prior discussions, Judge, that my client's daughter was present. She was, I think, 17 at the time.
My daughter was 15.
How old was she then?
My daughter was 15.
15, Judge. I
son was
apologize.
16.
This happened 2-3 years ago. And I think, I mean, that was one of the issues that I discussed with Ms. Reiser, and a lot of it was by phone, Judge, was not by email. But when she sent the DocuSign recommendation, was exactly what I wrote on that sheet.
I'm
And
just trying to make sure everybody's clear.
so
It doesn't seem like Ms. McCutcheon's, by the look on her face, is clear with the null cross of the second count. Am I misreading you, Ms. McCutcheon?
Judge, and you know what, I've been accused before of being very animated. I try not to be, Judge, but and Mr. Haddad, respectfully, Your Honor, and to the court and to opposing counsel, the plea paperwork is silent as to the cruelty to children. It does not mention the sentence, yet it also does not mention a null cross. I've even gone back into our internal system, and I do not see any notes reflecting what is to be done with the cruelty of children. So of course, I, as the assistant solicitor handling the case today, would not be inclined to null cross the cruelty of children based on the facts in this case, and based on the also the additional fact that I don't have any reference of what Ms. Reiser intended to be done with that. There is no indication that it was to be null crossed, Mr. Haddad. If you have an email that you can forward to me, I know Ms. Reiser is not available today to show that, but I don't have anything in my notes from Ms. Reiser to that effect.
I can double check, but I'm pretty sure that there was nothing other than phone conversations and the recommendation, which is what I had, what's in the sheet. I mean, honestly, at this point, Judge, it sounds like, I mean, as much as I want to resolve this case today, and really, frankly, it's because my client just wants some closure to this.
Can we, maybe we can do this. I'm going to be here all day tomorrow. You're going to be here, Mr. Haddad?
Unfortunately, yes, Judge.
Now you're just hurting my feelings.
No, only because I'm spread thin tomorrow, Judge. So if the court would allow it, well, I don't know if Ms. McCutcheon can get hold of Ms. Reiser. I mean, really,
I mean, I think this is a big deal, you know, if that's going to be null crossed or not. So if you want me to give you the time, and if Ms. McCutcheon, if you can, or Mr. Haddad, get in touch with Ms. Reiser so you all can come to terms, given that it's, it's her case. I mean, I think if it's gonna be null crossed, I'm willing to give you overnight to get it null crossed so that we can deal with that. If that's what you would like for me to do.
And that's fine, Judge. Can my client report by Zoom tomorrow? I will reach out to Ms. Reiser.
That's fine. We have all the paperwork done. We'll keep that. So she's gotten everything filled out. So if she wants to be here by Zoom, I'm happy to have her here by Zoom.
Would the court entertain, since she's physically here, perhaps to go through the plea questionnaire and hold off on sentencing until we resolve, or we can just do it from the beginning tomorrow, and that's fine too. Either way, it won't take but 2 minutes.
Takes 5 seconds.
That's fine. So let's do
Yeah,
that.
I prefer to do it all at one time, to have it, all in one bundle, if that's all right with you all. So,
And I don't blame you, Judge. So I'll check with Ms. McCutcheon. I think I have Ms. Reiser's cell phone. I try not to bother people when they're on a seminar, but this is kind of an unusual situation.
right. So hopefully we can get this taken care of tomorrow.
All right, thank you, Judge.
All right.
Yes, Judge. And I've texted Ms. Reiser. She may not be able to respond because she is also attending and presenting at this training, but I'll have a response to the court by tomorrow.
Okay, thank you, Ms. McCutcheon.
And is this at 9? Is it 9 tomorrow, Judge? Or the afternoon?
We've got 2 calendars.
Judge, I prefer 1:30. 9, I have Superior Court as well.
Okay.
And I also have Superior Court at 1:30, but I prefer 1:30 because I actually have cases on the calendar. So.
Okay, 1:30 tomorrow.
Thank you.
Your Honor, I'm sorry to interrupt. If I could, before everybody disperses, if I could just briefly speak with ASG McCutcheon in a breakout room, because I have a similar situation with a battery family violence case. So I may have a resolution before everybody leaves.
Okay, but we still have some of your pleas to take, Ms. Riley.
Correct.
Are any of those ready to go?
They are ready, but before Miss, and I'm sorry, I didn't catch her name, but before she leaves and we delay this till tomorrow, I may be able to resolve it today. So that's why I was.
Okay.
Yeah.
So they're saying don't leave.
Yes, if I could just speak with ASG McCutcheon.
Okay.
Okay.
So you'd like to be placed in a breakout room with Ms. McCutcheon right now?
Yes, please.
So we can get that done. They're gonna try to resolve something, Mr. Haddad. So maybe we can get this resolved today. So if we can place Ms. Riley, Ms. McCutcheon in the breakout room, everybody else, I appreciate your patience. We'll get to you as soon as we get the paperwork.
And Judge, that was not I enjoy being in your courtroom.
I'm just teasing you,
Tomorrow,
Mr. Haddad.
days, I'm in 5 different courtrooms. I kind of wish I wasn't. Comes with the job, right? That's fine.
Monica, do you want to still check the
Thank you for the time, Your Honor. Actually, while I was speaking with Ms. McCutcheon, Ms. Reiser responded, but we are going to move forward with the plea today and no prosecute the cruelty to children.
Okay,
Yeah, Ms.
very
Weiser
good.
indicated that was part of the negotiation that she had agreed to that. So Mr. Haddad, is he there?
Yes, he is.
Ms. Reiser affirmed that she had agreed to no pros that.
Wonderful. Thank you. Thank you for following up on this.
So I'll present a no pros, Judge, and email it to, do I email to you, Ms. Redden, or to the Orca State email address?
You can email it to the state.orca.
State.orca, okay.
Yes, ma'am. Thank you.
Okay, was there anything else before I take the plea?
Nothing additional from what I've already stated, Judge.
Okay. Mr. Alterman, can you raise your right hand? I'm sorry, I don't know if I swore you, and do you swear affirmative testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. It's my understanding, Ms. Alterman, that you wish to plead guilty in count in case 21 CR 004661F to battery family violence. Is that correct?
I suppose so, yes.
It has to be a yes or no, ma'am.
You want to resolve it today? You know.
All right, just take a moment. Just take a moment. Take a breath. Have a seat. Yep. Okay, hold on. Just take a breath, have a seat for me for a moment.
Just, oh, please, oh, please.
Okay, I want you to get yourself together first, okay? And we'll get into other paperwork together, Ms. Riley. I hate to, I keep asking.
Sure, Your Honor. Attorney Rockwell sent it to both myself and I think she sent it to Essence Smith. So that may be why you don't have it back yet. So I will forward that to Ms. Redden just a moment.
And what about for position number 1?
I emailed that paperwork, I believe, to Ms. Redden and state.orca.
Yes, she did, and the attorney is looking at it.
Okay, now, okay, thank you.
Okay, sure.
One of those days.
It is. It absolutely is. Oh, Jesus, Ms. Rockwell.
Do y'all want to just use the first one and scratch it out yourself? I mean, that's the recommendation. That is what changed. The judge, after hearing from the state, could always sentence him with a change of condition, no further violent contact. The victim lives in California.
You mean for all of us to hear that, Ms. Rockwell? I'm not sure.
Yes, sir.
Okay.
I know that y'all were trying to see about my second submission, Judge.
Okay.
There was an offer, the recommendation in from Madam Prosecutor was no further violent contact. I'm sorry, no further contact with the victim in Kerry Blumenfeld. And it's being changed, Judge, to no further violent contact. The victim does live in California and has contacted me on many occasions to express the wish to have contact, father-son.
And I'm sorry for interrupting, but Attorney Rockwell, they don't have that paperwork yet because Ms. Redden is in court today and it was sent to Ms. Smith. So I just need to sign it and send it to Ms. Redden.
Oh, I am so sorry.
No problem.
Let me be quiet and get back on my email. I'm
No
sorry,
problem.
Judge. I'm sorry.
Oh, no, you're fine.
I think we're ready whenever the court is.
Okay.
Judge, real quick, could somebody just put the proper email address in the chat for me to submit my paperwork?
Okay, we'll have someone do that, Ms. Rockwell.
Well, hold on, Ms. Rockwell, you don't have to, because I have to sign it. So if you submit it, it won't have my signature on it. So
Very
I'm
well.
gonna send it. I'm gonna send it to Ms. Redden.
Thank you so much.
Okay, thank you.
Okay, Ms. McCutcheon, are you with me?
Yes, Judge, I am. Mhm.
Okay, Ms. Alderman's ready now, so we can proceed. And my question was in case 21 CR 004661F, that's my understanding that you wish to plead guilty to battery family violence. Is that correct, ma'am?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this afternoon?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
I understand.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated. The first offender was asked for, given the age of the case and there's no other types of allegations of this nature in her past, I'll allow that.
Thank you.
As far as the getting herself back on her feet, I will give her 3 months to get herself a job. So I'll waive 3 months of the probation fees for her to help her get and stay on her feet. I am going to require though that it's 12 months of reporting probation, but I'll try to help her out with the 3 months. Was there any other requests?
No, that's it, Judge. Thank you.
Okay, all right. Good luck to you, Ms. Alderman. So what we'll do is I would like you to report to probation in the next 2 weeks or so. We'll give you the forms to fill out of where we need to go. And good luck to you, ma'am.
Thank you, Judge. We already filled out the paperwork. so
Okay,
we're
very
good.
good.
Thank you,
And
Judge.
Your Honor, yes, and Your Honor, I am emailing the null pros order now and copying you, Mr. Haddad, as to the cruelty to children.
Okay, thank you.
Thank you, Judge.
You're
Can my
welcome.
client be excused?
Yes, have a good afternoon.
Thank you.
You're welcome. Let me know when you are available, Ms. Riley, so I'll take Mr. Dusmed's plea.
Yes, Your Honor, I am sending the last email to Ms. Redden now, so I can go ahead.
Okay.
That's the other one, Ms. Rockwell's first.
Is it Abdusmed?
Yes, sir.
Yes, good afternoon.
Yeah.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down. Thank you, sir. Ms. Riley?
Thank you, Your Honor. The state would expect the evidence to show that on March 10th of 2019, officers were in the area, were called out to the scene for an accident in Fulton County. They observed Mr. Abdulzamed to be under the influence and actively resisting the officers while trying to take him into custody. On arrival, in terms of the traffic accident, Piedmont Road and Far Road. And he advised that he had been drinking earlier and he pulled out of the BP gas station and was hit by the second driver. When they spoke with the other driver involved in the accident, he stated that he was attempting, Mr. Abdulzamed was attempting what appeared to be a U-turn in the middle of the roadway, and that the other driver was unable to avoid hitting him due to that maneuver of him failing to yield. The state's recommendation, Your Honor, is to a plea of count 1 DUI. It's 12 months to serve 24 hours, credit for time served 24 hours, the balance on probation, a $300 fine, 40 hours of community service, an alcohol and drug evaluation, and any treatment that is recommended, to attend a risk reduction program and attend 1 victim impact panel. Counts 2 and 3, the failure to yield in the driving without a valid license would be merged or no pros. And the obstruction is 12 months probation, concurrent to count 1 and a $300 fine. And the state does not have an objection to probation being non-reporting upon completion of conditions.
Thank you. Counsel?
Nothing further, Judge. We would just ask that the court accept the plea as negotiated, Judge. Mr. Abdul-Samad has tirelessly learned his lesson and is looking forward to moving on with his life. He's already completed his alcohol and drug evaluation, 20 community service hours, and risk reduction class as well, Judge. We'd also ask the court for a certificate of first conviction.
Any objection, Ms. Riley?
No, Your Honor, this is a first DUI.
Okay. Mr. Abdul-Samad, it's my understanding in case 20 CR 004265Y, you wish to plead guilty to DUI less safe and obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this afternoon?
Yes, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. We'll get you the affidavit of first offender. And when you complete the terms, it'll go to a non-reporting status. So the sooner you get it done, the sooner you don't have to report to probation, okay?
Thank you, sir.
Anything further?
Thank you, Judge. And when would he be meeting with probation?
We'll have to fill something out. I asked that he get in touch with probation within the next 2 weeks, and you're not here with us today.
Okay, thank you, Judge.
All right.
And that concludes my business. May I be excused?
Yes, I appreciate your patience today.
My pleasure. Thank you.
Second.
Attorney.
Okay, I think the final 2 cases are Ms. Rockwell. So whenever you're all ready and we get that paperwork, we can.
Everyone, I have received the paperwork. That's the good news. Bad news is, unfortunately, the way it has been sent to me, in order to print it, I can't read any of the signatures, and I can't make the actual copy that I have darker to view those signatures, because I don't know if it was taken as a picture or if they were scanned.
I think it's because of the way it was scanned, et cetera, madam. Is this Miss Redding?
It is.
This is what I can do. I have in my email, and this is a promise. I have one of those fill in the blank, where you type it in and you can type it in, one of those fillable documents that has been sent to me in the past. Would you like me to fill those in and send them to you?
Whatever works best for you and Miss Riley, because I don't have a signature for either one of the way that it comes through.
And then the way we do that is we just put S/S for the lawyers. In other words, the whole thing is online.
How about this, Attorney Rockwell? I will just redo the paperwork and send it to you for a signature, and you can sign with express permission for your clients.
No problem.
Okay.
Knowing that that's going to happen, do you want us to do the paperwork, or would you rather us wait, Judge, until that happens?
I'd like to have the paperwork before.
Understand. And then what I was going to do is just have Madam Prosecutor sign my name with express permission, so it didn't get, so we don't have another light problem, you know, being too light for the, and we have been just doing S/ for the clients, judge, for the defendants, and the court just asks them on the record, you have permission for us to fill your name.
Whatever works for all of you all, I'm happy to do. So if that's agreeable with everyone, it's fine with the court.
Madam
Yes, Your Honor, I
Prosecutor,
believe-
will you sign my name with express permission? And then the court can allocate to the defendants whether or not they have permission for the court to fill in and it just be printed their signature.
Yes, I have no issue doing that, and because this is being recorded, you know, that is the transcript that you are giving me permission to sign.
Yeah.
For
Well,
the paperwork.
They're here.
The defendants are here, so
they're
they
here
can sign
themselves.
themselves.
Right.
Oh, well, that's even better. And I'll let Madam Prosecutor, I can say I've only been a lawyer 43 years, Judge, but I have never signed the prosecutor's name to anything. But I let them sign my name all day long. Shoot, they can have my rental property if they want.
Okay, my apologies. I didn't realize they were in the courtroom, but yes, I will redo those now and resend them.
Thank you.
Thank you.
I'll stand down, Judge. We're here. We're just happy to get this done today.
Okay.
So we'll stand down unless y'all are finished on everything.
These are the last two cases we have this afternoon, so.
Oh, okay. I didn't want to jump the line and have everybody, all the other lawyers waiting on me.
No, you're fine.
Section number 5 mistakes and then show it, right? I don't know what's going on with that.
Is it still coming through like that?
Well, no, she's gonna redo it. But
Oh,
that's the reason why I
okay,
can't
right.
accept it because
We can't see it.
read any.
Right.
Can you tell Randolph he's printing his documents to the printer down here in the courtroom? Thanks. Oh, thanks.
Okay, Ms. Redden, I did just send those, so hopefully they're correct this time. And also, Ms. Redden, is it still the policy for any counts that are null pros, that there be a null pros order placed? Because I don't.
Yes, ma'am.
Okay, then I will work on those. Thank you.
Thank you.
Okay, are we ready on Mr. Bloomfield?
Yes, sir. I am.
Good afternoon again, Mr. Bloomfield. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, nothing but the truth? That's right. Put your hand down. Thank you. Yes, Ms. Riley.
Thank you, Your Honor. The state would expect the evidence to show that on October 16th of 2021, officer was dispatched to Cranberry Creek in Roswell, Fulton County. Upon arrival, spoke with the victim, who is Ivan Bloomfield, who stated that his son, Mr. Kerry Bloomfield, attacked him. Officer observed, or was told after an argument, that Mr. Kerry Bloomfield punched Mr. Ivan Bloomfield in the back and kicked him. And this was in front of two small children, I believe, the grandchildren of Mr. Ivan Blumenfeld. The state's recommendation in this case, Your Honor, is 12 months probation for count 2, battery family violence, 12 months probation, a family violence intervention program, and to have no further violent or harassing contact with his father, Mr. Ivan Blumenfeld. Your Honor, I believe that it is Attorney Rockwell's intention to ask for first offender. The state will object due to it being a family violence offense, but will note that it's still in the court's discretion, and this is his first and only arrest. Thank you, Your Honor.
Ms. Rockwell?
Yes, Judge. Thank you so much. First, for the record, I am happy to represent Mr. Blumenfeld. I have known him for many, many, many years. I do know his father. I know his mother. I knew his sister. Anyway, for the record, Judge, he is 37 years of age, born in Birmingham, Alabama, graduated high school, went on to college at Georgia State. He is married. He does have 3 children, 3 sons. He owns his own real estate brokerage firm. And I do apologize. I did not know that if that was policy for the district, I'm sorry, for the solicitor's office. I do remember speaking with Ms. Reiser that we had discussed on both cases whether or not my clients were eligible for first offender, and I understand that both individuals that I have on the calendar today, I am not stating as an officer of the court that that discussion was had, and I frankly did not know that the state was objecting to first offender. I do understand if that's some kind of new policy. I always, I know that the solicitor's office has taken a stance for restorative justice, and when you have individuals that have enjoyed a good record, Judge, I mean, thank goodness it is up to the court. I will tell you that I asked Mr. Blumenfeld to complete the family violence intervention course, which is a 24-week course. He did that without blinking an eye. Everything I've asked him to do, he has done. As a matter of fact, I'm in contact with the victim in the case and also with a number of witnesses that were in the case. I think if the case went to trial, the evidence would have shown that this happened at a family gathering, and the family was actually trying to get the alleged victim in the case out of the house because of some confusion, and the victim was trying. Everybody was just trying to get the victim out of the house because of some. I don't want to talk about the conduct other than, Judge, they were trying to get him out of the house, and he kept trying to re-enter the house. And at that point, there may have been some conduct that would have resulted. But obviously, Judge, me speaking with the victim, and I could try to get the victim on. Frankly, I did not know that I was going to be met with any opposition to the first offender. But I did not know how the court felt about first offender. If they would have asked Mr. Blumenfeld to do anything else other than the family violence intervention course, obviously he would have been happy to do it. I do know, Judge, that in real estate industry, I don't think you can have a hiccup, not even a hiccup on your record. So for that reason, other than the reason that his father, Dr. Blumenfeld, would not want this to affect his future. I know Dr. Blumenfeld wants to have an open line of communication, not only with Mr. Blumenfeld, but also with his wife and with his children. So based on that, Judge, I'm going to ask that the court follow the recommendation. I do know that in the event that what I typically ask for is once finished with all the conditions for the probation to go non-reporting or to terminate. But I do know also with first offender, you have to be on some type of probation. I think that the most important thing that the state would be asking for, obviously, is to have no more conduct violent conduct with the victim. And I can assure you that that is not going to happen, Judge. So based on that, I'm going to ask the court to accept the recommendation, allow him first offender, and I always send, I think that the request that I need to make today, Judge, is that Mr. Blumenfeld's right to privacy outweighs the public's interest in knowing what happened in court today. So I have a motion in order for a record restriction and a seal of the clerk's records, Judge. In the front side, I know the court is aware that in 42-8-62.1 now, first of all, I know that you don't see too often first offender in misdemeanor court, because lawyers usually try to talk individuals out of using first offender, which is a real trump card in a misdemeanor case. But sometimes it's important enough. I know if I had a misdemeanor, I would use my first offender. Sometimes it's important enough to the client to have the record, not only first offender, but also to have the record sealed. So I'm going to ask if the court would also consider the record being sealed, even though it's a misdemeanor, based on the 42-8-62.1. Now the law authorizes the court to seal on the front end and not wait till first offender is completed. Based on that, Judge, I ask that the court accept the recommendation and grant first offender.
And
Ms. Riley?
Your Honor, just the state would object to any records being sealed on the front end, because as we know, if for whatever reason the first offender treatment is removed, or if there are any violations, then this will be sealed and they have not, and he would not have completed first offender. So we would object to it being sealed prior to this being completed.
And Judge, the only thing is that just, and I understand prosecutor's position, when you're on probation, Judge, if there's and this is how we do it in felony court, not to keep bringing up felony court, but if you're on first offender and it's under seal, all you have to do, it's a 2-second motion. It's an order opening, unsealing the record. I could send that. We do it all the time when we go back in, when there's any kind of revocation or probation, we unseal the record and do the probation revocation, and we have to make another motion to seal it back after the record is, or after the revocation is had, Judge.
Okay, anything further before I take the plea?
No, Judge.
Okay.
Your Honor, the state would just stand on its objection to sealing prior to completion of the conditions.
Mr. Blumenfeld, it's my understanding that in case 21 CR 005579M, you wish to plead guilty to battery family violence. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, sir.
I will accept the plea as negotiated. Let's see. I am going to allow you to have a certificate of first offender, Mr. Blumenfeld. I will also allow it to be sealed, knowing that if you do not complete the probation properly, that it will be unsealed. How much of the FVIP has he done, Ms. Rockwell?
Every drop of it, Judge. You know, the client used to be a lawyer, right? You know, you would sometimes have a client from hell. Judge, this is a client from heaven, okay? Let me just say that. We need a lot more clients like that. He did everything I asked him to do.
Okay. So he's still going to have to report to probation. Initially, we'll give him that information today. So I'll ask that you report within the within the next 2 weeks. The court appreciates you went ahead and getting all that out of the way. And because of that, I'm going to have once you report one time that you've done and you provide the documentation to probation, go to a non-reporting status. So you'll still be on probation for the entire 12 months to satisfy the first offender, but you don't have to report and you won't be having to pay the fees, okay?
Thank you, Your Honor.
And that's in large part because of you being proactive and completing what you needed to complete, okay?
Thank you.
Anything further, Mr. Blumenfield, this afternoon? Okay, if not, we'll get you we will get you the paperwork to sign as far as probation goes.
Okay, thank you.
Okay? So we'll be with you, sir. All right, Ms. Glover is next, I believe.
Yes, Your Honor.
Judge, as we're getting ready for her, may I send, I'll send it to Madam Prosecutor, this proposed order on this motion to seal. And who would my second person be? I'm sorry, I just don't know who else I'm sending this to.
Ms. Redding.
And what's the first name of Miss Redding?
Monica.
Oh, okay, that's right. I'm sorry. I sure did know that. Okay, Judge, I'm gonna stand there.
Good afternoon, Ms. Glover. Can you raise your right hand for me? That one, yes. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Sure. You put your hand down. Thank you, ma'am. And whenever you're ready, Ms. Riley.
Thank you, Your Honor. The state would expect the evidence to show that on December 23rd of 2018, animal control was called out to 111 Spalding Trail in Sandy Springs, Fulton County, to where they observed a pit bull that was owned by Ms. Glover in a wire crate with inadequate shelter in 32-degree weather. The crate was too small for the size dog, and they also observed that the dog did not have a Fulton County license or tag, excuse me. The state's recommendation is for a plea to the cruelty to animals, which is 12 months probation, or excuse me, 12 months to serve 4 days, credit for time served, 4 days, the balance on probation. Ms. Glover is to complete a BARC class, which requires her to have a laptop or some kind of computer to complete. And if she is not able to or does not have one, she can rent one from the program. But there should be a form that was sent to her, I believe, to fill out, or a link to fill out electronically. And I'm not sure if Ms. Reiser or whoever Ms. Rockwell has been communicating with has given that information.
And Ms. Riley, I don't have that. And frankly, this is not anything that I was real familiar with, this BARC program, but I do know that it's going to be online and it's not anything that's going to be extremely excessive or impossible to do. So we will figure it out. If not, I'll get back in touch with Ms. Reiser or yourself.
Okay. And I also believe in regards to this case that Attorney Rockwell will also be asking for first offender. And again, due to the nature of the charge, the state would object, but it is the court's discretion. Ms. Glover only has one other, well, it's 2 other arrests, but they are for this case, actually, one in Tybee Island or in Tybee, where I guess she missed her court date for this case. And then also a failure to appear from the Fulton County Sheriff's Office where she missed her court date.
Okay, Ms. Rockwell? You're on there, Ms. Rockwell.
So let me explain that. That sounded, I don't want the court to think that she's a scofflaw. She, that Tybee Island, Fulton County, what happened was, and the case you see, Judge, does have some age on it. This is a December 2018 case. And Madam Prosecutor and I were getting all excited about, well, wait, she's got another cruelty charge, maybe. So what happened, Judge, she was in Tybee Island and the police somehow ran her name and they saw that she had a Fulton County failure to appear. So she got taken into custody over there. And that was a nightmare in itself. They had to wait for Fulton County to come and get her. Then she got brought to Fulton County and then was released from Fulton County. So that was back in the day, Judge, before they had these immediate, real fast track, I guess you call it, where you get your, there's no area where you're gonna miss court. I think that Mr. Gamage has tried to seal that hole in the dam where you get disconnected from a municipal court all the way to the time that you get your case indicted. At any rate, I don't think that would that's going to happen anymore now that we have those immediate CR numbers upon arrest. A little bit about her, Judge. She is 23 years of age, born in Lawrenceville, did graduate from Mill Creek High School in 2018, did some schooling as an esthetician, but then went into the corporate world, and she is working with the in marketing. It's with the Target company. She is not married. She does not have any children. And this, as I understand it, she's not on probation, parole, any kind of suspended sentence, nor does she have any open cases. This is her brush with the law. So based on the age of the case, based on it, I think that the state would indicate that she's eligible. My understanding is that that the state would have been able to tell if there were any other brushes with the law, but based on the age of the case and based on the fact that she is eligible for first offender, I would ask the court to give her that actual chance. I believe everybody needs to get that second chance, Judge, and I think you will see that she's going to be a good risk on probation. I'd also ask that once she finishes her classes or class or however long this takes, that she go to non-reporting and she finish the year out so that the court will know that she's still under sentence and following all the rules.
Okay, anything further before I take the plea?
Nothing. I will be submitting if the court does grant that first offender the same order to seal as I'm going to submit to Your Honor on Mr. Blumenthal.
And Your Honor, again, the state would lodge the same objection to sealing of the record prior to the completion of first offender if the court is inclined to grant first offender.
Okay. Ms. Glover, it's my understanding that in case 19 CR 007909F, you wish to plead guilty to cruelty to animals. Is that correct?
Mm-hmm.
You have to answer yes.
Yes, ma'am. Yes, sir. I'm sorry.
Time, yeah, you're fine. Are you under the influence of any drugs or alcohol?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Given that this is your first offense, I will grant a certificate of first offender. When you complete the class, it'll go to a non-reporting status. So the sooner you get the class done, the sooner you don't have to report to probation, and the sooner you don't have to pay the probation fees. And I will go ahead and sign that the request to have the record sealed, but know that if you don't complete probation properly, that it will be unsealed. All right, anything further? I'm Ms. Glover. If not, we'll get to the, I would like for you to report to probation within the first couple of weeks.
Okay.
So we'll get you where you need to go to report, okay?
All right.
Okay, we'll be there. Thank you, ma'am.
Judge, I'm gonna stand down and listen. Y'all probably gonna go through the calendars. I'm gonna stand down and just make sure y'all don't need me. I'll just be listening to y'all.
Okay, thank you, Ms. Russell.
Thank you so much. And after that, may I be excused though?
Of course, yes.
Yes,
We'll
sir.
see you,
Thank you so
see you
much,
next
Judge.
time.
And thank you for helping us. You have no idea. Y'all are really moving a lot of cases with this Orca program, and I appreciate the staff, your prosecutors, everybody. We're getting it done, Judge. Thank you so much.
Yes. Thank you, Ms. Rockwell. We all appreciate that. So, Ms. Redding, when you're ready, okay?
Okay, Judge, we have someone who just appeared on Zoom. Position number 38. We announced FCA bench one. If he's not on Zoom.
Samantha Trishon. Ms. Trishon. Ms. Trishon, if you can hear me, you need to indicate that you do.
Hello? Hello? Can you hear me?
Not very well, ma'am.
Okay, hello, is this a little, I'm sorry.
Still, ma'am, we can't adequately hear you to speak to you. You need to get in a location where your internet.
I'm sorry, I'm trying to see if you guys. Okay, 1 second, I'm so sorry. 1 second, let me see if I can do this.
Okay, can you activate your camera? Mr. Haddad, this was Mr. Gaither's case that we're about to issue a bench warrant for.
Yes, I recognize the name, Judge. I just other than the name.
If I can get her on the line to make sure we can get her contact information, given that she's late appearing, but late's better than not appearing at all. So I won't issue a bench warrant, but I have to make sure that you all have her correct contact information.
Absolutely, Judge.
Mr. Ashana, can you hear me? Okay, while she does that, let's go ahead and go over the calendar.
Yes, I can. I'm trying to go on a different software. Maybe you.
You're gonna have to, whatever you, we can't solve the problem, Mr. Ashan, so you're gonna have to help us solve that problem. So whether you have to log out and log back in on another device, I need to speak with you, otherwise a bench.
Right, that's what I'm doing right now.
Okay, I'll give you that opportunity, but go ahead and try to get on another device if you can. Okay.
Sir. This is the final plea calendar. Position number 1, plea. Position number 2, request jury trial. Position number 3, request jury trial. Position number 4, plea. Position number 5, FTA bench warrant. Position number 6, negotiated plea. Position number 7, request jury trial. Position number 8, plea. Position number 9, jury trial. Position number 10, jury trial. Position 11, final plea, October 4th. Position 12, reset final plea, October 4th. Position 13, plea. Position 14, reset status, October 4th. Position 15, reset, August 3rd, tomorrow at 1:30. That's Mr. Haddad's
No,
case.
that ended up being.
Oh, she took a plea. Forgive me. That was initially before Miss Riley assisted us. My apologies. Position 16, reset bench trial, October 18th. Position 17, final plea, reset final plea, October 4th. Position 18, request jury trial. Position 19, request jury trial.
On position number 7, does he have an attorney, Mr. Fequa?
Position number 7, Michael Stinson.
Okay, thank you.
Okay, and on all these, I'm just gonna make this announcement, I guess, every time that I have jury trials that we're scheduling. And just so that I know that I've said it to everyone, and I'm trying to be fair to everyone, so if you'll go back and and I'm sure they'll hear it again from me, but we're putting them on a jury trial calendar at the present time. Everybody knows they're going on a jury trial calendar. I want well in advance if there needs to be a continuance because of a witness not being whether they are being certified or whatever. I want that to be done well in advance. I don't want to get up to the day of trial or the weekend before the next day of trial to inform the court of that. You know, everybody is working as hard as they can. And I know that, you know, the public defenders are getting up to speed on the case. So if you'll inform the court well in advance, and let's say, you know, maybe a week or two, just so that they don't expend energy when a witness is not available. So I'm gonna keep saying that every time I come, so that when we get there, we're all on the same page. Is that?
Well, Your Honor, I did want to say, and not sure if Ms. James has communicated to the JLs or whoever is supposed to communicate, but it's our understanding that moving forward, starting with August jury trials, that calendar call for both weeks, the 2nd and the 4th week, will be the first week of the month. I believe it's that first Monday or Tuesday of the month. And so that'll be the calendar call for the entire month. So if there are any witness issues at that time, that will be announced at calendar call to help avoid having to ask for continuances, or if there is a continuance, it would be to that 4th week of the month to avoid, you know, having to push it out further. Is that reasonable to the court?
And that's fine with me. I was not aware of that, but that's fine. I just want to make sure that, you know, when we get to the trial, that we're ready. Everybody's ready for the trial.
That is the trial. Absolutely. That is the goal.
Judge, the only request, and I don't think that.
Ms. Torshan?
Yes, I'm so sorry.
You're gonna have to turn off one of those devices now.
Okay.
She muted herself.
And you're gonna have to unmute your iPhone.
All right. I'm sorry about that. Thank you so much.
Okay, well, court started at 1:30, Ms. Torshan. What's the problem?
Yes, I did not receive any indication that I had a court date earlier today. I didn't realize that till I went to my email and I seen, my lawyer texted me or emailed me and notified me that I had missed it, and just to log in as soon as possible and see if there was any way I could have it rescheduled.
Okay, so a bench warrant was going to be issued since you were not here. So you're gonna have to make sure that, get in touch with Mr. Gaither, and you've got his contact information there. If you have moved, or if you telling the court that you didn't get notice, call the clerk's office or come down here to make sure that they have your proper information. Your case will be reset. And let's reset her until
October 4th. She going on a so-called or
I'm still trying to find her.
position number 38.
Okay.
Look that.
Okay, yeah, she's on the 9 a.m. calendar.
Yes, sir.
Position 38 on the 9 a.m. calendar, so we won't issue the bench warrant, and we're gonna put her on the October 4th status calendar.
Yes, sir.
Okay, so I'm gonna place you on an October 4th status calendar at 9 a.m. Okay, you're gonna get numbers.
Yes, thank you so much. Again, I apologize for the inconvenience. I had no notice. I expected to get a letter or something to indicate.
Okay, well, you have to make sure that you stay in touch with the court, get in touch with Mr. Gaither to make sure that that the court has your proper address so that you don't miss court again, okay?
Okay.
All right,
All right, will not happen again. Thank you so much, Judge.
okay, you're welcome. Have a good afternoon, ma'am.
You as well.
Okay, and so thank you for that, Ms. Riley.
Judge, the only question that I have, and I'm
Yes,
not gonna
Mr.
keep
Todd.
things long, and I'm sure I spoke to, but for all the lawyers, is some clarity as far as the trial calendar. What I mean by that specifically is that I know we have a calendar called the calendar August 8th, but just maybe on the calendar to know that the trial calendar lasts, August 8th, 9th, 10th, 11th, whatever dates encompasses, because I think, sometimes we don't know. I mean, I know, but some of the private attorneys may not know, okay, calendar calls on the 8th. What does that mean? Is the trial week, the rest of the year or not? Just
That's what it means. We have taken, who's ever gonna handle that calendar, we're handling for the week.
right, but and I understand that, but I think there's some confusion as to whether is a trial calendar the following week or does it skip to the 4th week? And I think
That's for the new way it's going on.
Yes, and Mr.
Okay,
Hurd and Miss Riley and Miss McCutcheon, what I will do is I will request that Miss James sends an email for clarity to the ASGs as well as the Public Defender's Office so that everyone is clear and on the same page.
Yeah, that's really all it was. Just,
Okay.
I mean, I spoke to Ms. James and I think I know, when we're having trials, but I think for other lawyers, they may not know, is it just this first and third week, first and second week? I mean, it's a little unclear.
Okay, all right, we'll see if we can clarify that. Thank you, Mr. Guy.
Thank you, Judge.
Okay, thank you all. Anything further this afternoon?
No, Your Honor, see you in the
Okay.
morning.
I'll see you first thing in the morning. Y'all.
Judge, it's Renee.
Yes, Ms. Rockwell.
Hey, Judge, it's Renee.
Yes.
Can I just verify that y'all got the 2 proposed orders that I sent on Glover and Blumenfeld?
Yes, I have an email.
I sent it to Monica Reed. Okay, I just need to make sure you got it.
I have from Ms. Rockwell.
Yes, we did.
Okay, thank you, Judge. May I be excused?
Yes, have a good afternoon.
Thank
Everyone,
you so much.
you're welcome. Everyone can be excused.